5, please, Mr. Speaker.
With your permission, Mr. Speaker, I'd like to answer question 5 with question 7. I regularly meet ministerial colleagues to discuss important issues of common interest, including on matters relating to the United Kingdom's exit from the Union. I am unable, I'm afraid, to talk about the legal content of those discussions because, as she will know, the law officers are bound by the Law Officers Convention neither to disclose the fact or content of that advice. But may I say to the Honourable Lady, I remain committed to considering what assistance that I personally can provide to this House on the legal implications of the backstop to ensure that they have what they need to make an informed decision. We have been engaging, Mr. Speaker, in focused, detailed and careful discussions with the Union, and we continue to seek legally binding changes to the backstop which ensure that it cannot be indefinite. These discussions will be resumed shortly.
Helen Goodman.
I'm most grateful to the Attorney-General for that very full reply. On the 29th of January, the Prime Minister told the House, "What I'm talking about is not a further exchange of letters, but a significant and legally binding change to the withdrawal agreement. It will involve reopening the withdrawal agreement." Given the response he's had in Brussels and the remarks of the French Minister on the radio this morning, can he tell us whether it is still government policy to seek a reopening of the withdrawal agreement?
Good question.
It is government policy to achieve the necessary change in the backstop which will cause me to review and change my advice. That is government policy. That is the discussions that we're having. I would say, Mr. Speaker, it's come to be called Cox's codpiece. What I am concerned to ensure is that what's inside the codpiece is in full working order.
Well, I hope everybody heard that. In the interests of the accessibility of our proceedings, in case anybody didn't hear, the Right Honourable and Learned Gentleman referred to Cox's codpiece. I have repeated it so the alliterative quality is clear to all observers. Patrick Grady.
Thank you for that breather, Mr. Speaker. They say that the definition of insanity is repeating the same thing and expecting different results. So, given that the Attorney-General has not and will not be able to change a single word in this withdrawal agreement, how exactly would he describe the government's plans to put it to a vote again in this House next week?
Well, the plans for next week are not mine to decide, but what I can tell the Honourable Gentleman is this. We are discussing detailed, coherent, careful proposals. We are discussing text with the European Union. I am surprised to hear the comments that have emerged over the last 48 hours that the proposals are not clear. They are as clear as day, and we are continuing to discuss them.
Sir William Cash.
Thank you, Mr. Speaker. Will my right honourable friend give Parliament 48 hours or, at any rate, properly full notice of the outcome of his discussions with the EU? And will he provide to Parliament a draft of the Withdrawal and Implementation Bill so that my European Scrutiny Committee and others in Parliament and others outside can assess how the withdrawal agreement will be enacted in domestic law, as obliged by Article 4 of the withdrawal agreement, how the bill would ensure the statutory manner in which the express repeal of the European Community Act 1972 will be dealt with, and how the question of disapplication by the courts by the Supreme Court will be handled under that enactment.
Well, can I say, Mr. Speaker, to my honourable friend, we will endeavour to give as much notice as we possibly can. Of course, these discussions are running. They're going to be resuming very shortly. They're going to be continuing almost certainly through the weekend. And we will endeavour to give the House as early notice as we can, if and when we have something to report. Now, the second point he makes about the bill, Mr. Speaker, is not, I think, for me to decide, but certainly I will discuss it with those who do, and we will endeavour to give his committee, and indeed him, the earliest possible notice.
Mark Francois.
Thank you, Mr. Speaker.
The Attorney-General is now in the interesting position that he is leading on these negotiations. So to follow his own nomenclature, he will end up examining his own codpiece in front of the House of Commons. How can he provide objective advice to this House on which we rely when he will, in effect, be marking his own homework?
Well, Mr. Speaker, the law is the law. The question as to whether or not whatever is negotiated with the European Union affects the legal risk of indefinite duration of that backstop is a matter that I shall judge entirely impartially and objectively, because if I didn't, first, I would be conscious that there are many, many lawyers eminently capable of deciding. You may be right, from a sedentary position, too many, but eminently capable of deciding whether I've got my judgment right or wrong.
Hilary Benn.
Thank you very much indeed, Mr. Speaker. Article 175 of the withdrawal agreement, which, as the Attorney-General knows, deals with resolving disputes about the interpretation of the agreement, states that rulings of the arbitration panel shall be binding on the EU and the UK. In his letter to the Prime Minister of the 13th of November, the Attorney-General said that although the withdrawal agreement does not expressly state that the backstop review mechanism is intended to be arbitrable, I consider that the better view is that it is. In his recent discussions with the EU, have they confirmed that they share this better view? In which case, why would one need to consider another separate arbitration mechanism dealing with the backstop? Or has the EU said that it doesn't regard binding arbitration as applying to the backstop itself?
It is a question that I would have expected from so sophisticated a chairman of the committee. The problem is that even although the arbitration system applies to the protocol, the question that one asks the arbitrator is at the heart of the effectiveness of any arbitration. And although I am not at this stage able to disclose to the Right Honourable Gentleman the question that has been proposed by the United Kingdom to the Commission, it is the question that is everything. And that may very well be something that he needs to take into account, because the question about when the protocol would end is likely to be the determinative of whether or not the mechanism is effective.
Bob Neal.
Thank you, Mr. Speaker. I'm glad to see that the Attorney's powers of alliteration have not dimmed since we first appeared in court together, and I know neither has his independence and rigour and respect for his constitutional position, which should never be questioned. Will he agree that it is inevitable, when dealing with important matters of textual analysis and detail, that it is unhelpful to attempt a running media commentary on such matters? It is inevitable that such commentary it will be partial and inaccurate, but it is best that it is pursued with care and rigour, with the overall objective which he has just given to the Right Honourable Member, the Chairman of the Select Committee.
I'm most grateful to my honourable friend for that question, because of course he is quite right. The fact is that in any negotiation of this kind, we are dealing with complex legal questions and matters. And the running commentary, partial, often based on hearsay and rumour, is not helpful to the analysis of this question, or indeed to the conducive to the success of the negotiations.
Order. I'm sensitive to the fact that this issue is of enormous, for some, consuming importance, and therefore I want to let the question run. But colleagues really must now ask short questions of a sentence, and the Attorney will treat of them as he sees fit. Mr. Gavin Robinson.
Mr. Speaker, and I understand the privileged conversations that the Attorney has with the Cabinet, but has he turned his mind to the concerns that, should the backstop be indefinite, it is likely to breach the commitments under the Belfast Agreement, and indeed commitments that are given to me as a Northern Ireland citizen under Article 3?
If I were to answer that question, the honourable gentleman knows that I would be breaching the Law Officers' Convention. All I can say is I turn my mind to a great deal of the legal implications of the treaty, and those that he has mentioned have not escaped me.
Ford.
Thank you. The withdrawal agreement, of course, contains many issues that we all agree on, such as citizens' rights and a transition for business. Is it still the EU's negotiating position that in order to reach agreement on our long-term relationship, we need to agree a withdrawal agreement first?
Yes.
Thank you. Joanna Cherry.
Mr Speaker, the Northern Ireland Protocol is there primarily to protect the peace process. Yesterday, the Secretary of State for Northern Ireland made some rather unfortunate comments that killings during the Troubles at the hands of the security services were, and I quote, not crimes. Has the Attorney-General advised her that her comments were ill-informed, insensitive and, seriously, potentially contemptuous of the current legal process wherein the DPP is shortly to announce whether prosecutions will be brought against soldiers for unlawful killings on Bloody Sunday? And will he please tell his colleagues to be more mindful of these conventions in future?
I think the Honourable Lady knows that the Secretary of State has, I think, corrected those comments. I don't think it's necessary for me to advise her as to the various matters that she suggested I should. I believe firmly that the Secretary of State will not have intended any offence, and she has in any event corrected the remarks.
Nick Thomas-Symonds.
Mr Speaker, now should the Attorney-General have a more successful trip to Brussels tomorrow than he's managed so far this week, it's widely reported that he will be putting any concessions that he receives on the backstop to a star chamber of Eurosceptic lawyers, 1 QC, 6 Tory MPs and 1 DUP MP. Why are there no MPs from other parties in the Star Chamber?
No, I assure the honourable gentleman I shall be putting it to the Star Chamber of this House. I'm delighted that there are 8 very distinguished Conservative members who are going to sit in judgment on my opinion, but I expect and welcome the judgment of all members of this House on both sides of it.
Nick Thomas-Symonds.
I really hope the Attorney-General appreciates the fundamental concerns here, because he now seems to be both part of the negotiating team and advising the government on the outcome of the negotiations. Then it seems he will be putting his proposals to the Star Chamber, then he'll have to answer to this House. So will he now commit, first of all, to publish any advice he gives to the Prime Minister on any concessions he receives, and secondly, will he record what is said by him in this Star Chamber so that all MPs can make a decision Tuesday on exactly the same information?
The honourable gentleman is labouring under a misconception. I'm not appearing before any Star Chamber, either on this side of the House or the other. The Star Chamber I'm appearing in front of is this House. I will account to this House. And any Star Chamber, I'm not going to be appearing in front of them, although they are composed of, I say, exceptionally distinguished people. But any member of this House can come and see me if they like, and I shall account in this House. So I say to the honourable gentleman, do not grieve, because I shall, I assure him, be wholly open about my advice. He asked me will I commit to publish it. I will commit now to saying to this House that I shall publish by legal opinion on any document that is produced and negotiated with the Union.
Deirdre Brock.
6, Mr Speaker.
Mr. Speaker, sir, I'll take this, if I may, with question 6 and 10. With question 10, the priorities of my office in the published business plan. In relation to the UK's withdrawal from the Union, my priority continues to be supporting the successful delivery of the government's objectives by giving legal and constitutional advice within the government, in particular by contributing to international negotiations. I take a keen interest in the programme of Brexit-related domestic legislation, and I'm of course involved in supporting preparations for future international cooperation with the law officers' departments and the prosecution agencies.
We're running late,
but I am willing to accommodate colleagues. But I know that the Honourable Lady, notwithstanding any advanced text she has penned, will express herself with admirable succinctness, which reflects the urgency of the situation. Deirdre Brock.
Attempt to be pithy, Mr Speaker. We now know the Department of Transport's botched tendering process for ferry contracts has already cost the taxpayer £33 million to settle legal action. Can the Attorney-General tell us whether similar tendering processes across government could mean further litigation and how much public money has been set aside for the contingency of such court action?
The Honourable Lady knows that she's asking me questions that belong to the Department of Transport, not to me. These matters don't come to the law officers unless they have a law officer's point. So the reality is, I'm afraid I must direct her to my right honourable friend, the Secretary of State for Transport.
C. MacDonald.
Will the Attorney-General therefore confirm whether or not he provided any legal advice to the Department for Transport in relation to that contract and the settlement with Eurotunnel? And if he did provide that legal advice, given the huge public concern about it, will he publish it?
The honourable gentleman, it grieves me to have to say to him, he knows that I will be bound and am bound by the Law Officers' Convention not to disclose either the fact or content of my advice, if any were given on that subject. I'm sorry.
Mr Speaker, the Attorney and I are the pro bono champions of government, and as part of this, I work closely with those involved in public legal education, supporting initiatives to increase its profile and to reach